a drunk beaver. Yeah, I'm a drunk beaver. Chugging my beer while producing my stuff. Drunk Beaver Productions. Ooh, 'cause I'm a drunk beaver.
Welcome back to Drunk Beaver Production. Wow, did y'all love the new intro? There's a lot of new stuff here at our relaunch party, including monetization. So if you haven't yet, please turn on your gifts, hit that like button, and go ahead and subscribe. Today we're visiting Judge Meinecke's court. We have a case involving a car and some stolen parts. We also have a case about property line disputes. It should be a really exciting day, and I am so glad to be back with all of you. Thank you so much for your support while I relaunched my channel, and I look forward to the future. Have a wonderful day, and let's get on with the show.
And this has been the second time I have looked at this vehicle.
And you are familiar with car enthusiasts, am I correct?
The same officer reviews the same car, and he's got a whole new set of stolen motor parts in the 401002. We will be now.
Good morning. Good morning, Aaron. This is Mayor Milos on behalf of people.
And good morning, Acting Please out of the court, Richard Tim, the officer holding on for Pernell to stand to my right. Pernell, please state your name for the all around.
Right, please, 8 times set for further examination. Ready to proceed?
Yes, Your Honor. The people have 2 witnesses today, Detective Meckel and Officer Jake Way from Tri Police Department.
Okay. Anything else for the record before we get started?
I see only the 2 officers, I believe, so there's no need for sequestration.
That's correct.
Okay. My first witness, please.
Yes, I'm calling my first witness, Detective Meckel, to the stand, please.
Raise your right hand. Swear to tell the truth, the whole truth, and nothing but the truth, so help you God. I do. All right. Seated. Please state your full names, spell it for the record, please.
Detective Zachary Meckel, Z-A-C-H-E-R-Y, last name Meckel, M-E-C-K-L.
You're a witness.
Thank you, Detective Meckel. Where are you employed?
Royal Police Department,
And your job title?
detective.
How long have you been with the Royal Police Department?
November will be 5 years.
Okay. Did you become involved in an investigation regarding someone by the name of Olarian Purnell?
I did.
Can you please tell me about that investigation?
So I was assigned the case on 5/20. I was aware the arrest was made on 5/18 of Mr. Purnell in the
To
parking
be
lot.
clear, what year was that?
2024.
Okay. Proceed.
So I was made aware of an investigation that was being done with our road patrol officers as well as a Troy SIU officer who was reached out to for assistance in getting Mr. Jake Way to come and examine the vehicle. I was made aware of the investigation, came in and started quarterbacking everything. The arrest was made on 5/18 in the parking lot of Woodward Corners, Red Oak, that area of 13 Mile Woodward. It's the county of Oakland and the state of Michigan. Mr. Purnell was arrested for some outstanding felony warrants for Utah. I believe there was 3 counts of it.
Okay. And so once he was arrested, what if anything happened next?
Once he was arrested, I was put in touch with Officer Jake Way from DPD, who assisted me in examining the vehicle. He performed a van inspection, found that numerous items within the vehicle were stolen.
Okay.
Vehicle parts.
Do you see Mr. Purnell in the courtroom today?
I did.
Can you point to him and identify something that he's wearing?
He's wearing a blue scrub top.
Your Honor, can the record reflect that the witness identified the defendant by article of clothing?
Any objection?
No objection.
Record so reflect.
Without getting too much into specifics, because I have Officer Jake Way that's going to testify today as well, did you conclude that there was parts stolen during your investigation at the impound?
Yes, Officer Jake Way gave me a VIN number from the parts that were in the vehicle that came back to, I believe it was a 2022 Dodge Charger that had been stolen out of either Dearborn or Dearborn Heights.
Okay, and
Prior.
what was the value of those parts?
The exact breakdown I don't have in front of me, but it was, I believe the motor was valued based on looking it up online, which is the best resource I had for finding direct replacement parts from Mopar, which is the provider for Chrysler. I believe the motor that included the supercharger that was on it was about $17,000. I think the transmission was $10,000, and I'd have to review my report to tell you the value of internal components.
Would it help if I refresh your memory?
Yes.
Okay, is it okay that I use your police report? Yeah. Are they a close witness?
Hey,
It's this sheet. So go ahead and look at it, and then once you're finished reading, you can look up and you can tell me the rest of the values. Has your memory been refreshed now?
Yes. The value of the radio was approximately $1,700. The internal components of the vehicle had the complete interior from the Dodge Charger that was taken. That was an estimated value based on the part prices between $15,000 and $20,000.
Okay. No further questions for this witness?
yeah, thank you. So that I can understand this. The vehicle was taken into custody, or taken into possession of the Royal Police Department after Mr. Tornado was taken into custody, am I correct?
Correct.
And that was based on a warrant, a felony warrant that you saw in your system, or the officers that were initially investigating this matter saw in your system.
That's correct.
The vehicle itself was towed and placed into impound
That's correct.
as by way of policy of the Royal Police Department.
The vehicle was impounded and sent to arrest, yes.
So there were further investigations done as it relates to the vehicle.
Yes.
I believe you indicated, and I know he's going to testify, it was Officer Jakeway that came from Detroit Police.
Yes, I was put in touch with Dr. Dickler.
And did your initial investigation indicate that the title to the vehicle was a legitimate title to Mr. Purdue?
I was never provided a title to the best of my knowledge.
What about registration?
The vehicle is registered to District Purnell, yes.
Was, to the best of your knowledge or recollection, was there any proof of insurance or anything of that nature that was in the vehicle or associated with it?
I did not know that.
But at minimum, and what about the plate itself?
The vehicle is registered to Mr. Purnell, yes.
But it was based on the information provided to you through Officer Jakeway, it was your conclusion that there were items that were inside of this vehicle that were determined to be stolen from a Dodge 2022 Dodge Charger out of Dearborn Heights.
Based on the VIN numbers that were stamped on those items, they were stickered on those numbers, those items were thought to be stolen from a stolen Charger.
And correct me if I'm wrong, the VIN number to the actual vehicle did not match the VIN numbers to those items that were stamped.
That is correct. The VIN number stamped on the components of the vehicle were from the stolen Charger. The VIN number that was stamped on the actual Chrysler 300 was registered to Mr. Purnell.
No further questions.
Anything further?
Nothing further for this witness, Your Honor.
You may step down. Next witness.
People will be calling Officer Jakeway to the stand.
Sir, please raise your right hand. Swear to tell the truth, the whole truth, and nothing but the truth, so help you God.
I do.
All right, please be seated. Could you state your full name for the record, spell it, please?
It's David Jakeway, David Jakeway.
Your witness.
Thank you for being here, Officer Jakeway. Where are you employed?
For the city of Detroit, Detroit Police Department's auto theft unit.
And what is your job title?
I am a vehicle identification technician.
And how long have you been in that position?
As a civilian since 2014, so the last 10 years. And then I was with the auto theft unit as an officer from 99 till 2010 when I retired.
Oh, thank you. And are you part of any specific task force?
Just our auto theft unit. It's the commercial auto theft section.
I'm a little bit not used to cars. Can you tell me about that unit?
We handle all the stolen vehicles in the city of Detroit, carjackings and stuff like that in the city of Detroit. I identify all the cars, burned up cars, cars with parts changed, cars with parts missing, parts of vehicles that are found. I do all that stuff for the city of Detroit, myself and my partner.
Awesome, thank you. And I'm gonna direct your attention to May 20th, 2024. Did you assist Detective Meckel in a VIN inspection for a 2015 Dodge Charger?
That was for a 2015 Chrysler 300.
I'm
Yes, I
sorry,
did.
Chrysler 300. Thank you. What if anything did you discover while you inspected the Chrysler 2015 Chrysler 300?
When I first looked at the car, it's a white Chrysler 300, had a Hellcat logo on the side. The hood was missing. The engine was a large V8 engine with a supercharger. When I looked at the public VIN on that 300, that vehicle should not have came with that motor. It would have came with a 3.6 liter V6 engine, according to the VIN number on the vehicle. This was, as I said, a 6.2 liter V8 supercharged engine. So the first thing I did was identify that motor, and I did, and that came back to a 22 Dodge Charger. When I had that vehicle ran in the lease system, it came back as a stolen 2022 Dodge Charger, stolen out of Dearborn Heights. In fact, as of today, it is still has not been recovered.
Okay, and besides the motor, did you notice anything else of any other parts while inspecting this vehicle?
After I inspected the motor, I also inspected the transmission, which also matched the motor. So that also was stolen. Then I went into the vehicle and observed the dashboard, the seats, the center console. They were all consistent with a Dodge Charger, not with the 300. So I inspected those and also identified those as being from the stolen 22 Dodge Charger also.
Just to be clear, so all these parts were all consistent with the one vehicle, the 2022 Dodge Charger?
Correct.
Can you explain to the court the process for matching the VINs?
It's just looking for either VIN numbers, or there are other label numbers that can be cross-referenced to a particular VIN. All these parts had a VIN number assigned to it. And this has been the second time I looked at this vehicle. I looked at this vehicle in 2023 also, in March of 23. At that time, it had stolen parts on it to a 21 Dodge Charger. That vehicle was impounded in the city of Detroit, and our tow lot removed all those stolen parts from that vehicle before it was returned to the defendant here.
And just to be clear, the same 2015 Chrysler 300 vehicle we're talking
This is the exact same vehicle I looked at in March of 2023. It's the same car I looked at in May of 24, with different parts in it, of course.
Give me 1 second. Okay, no further questions for this witness unless you do, Your Honor.
No, Mr. Chair?
Mr. Jackman, I'm gonna count I would expect college your expertise in this area and some of my nativity. You indicated that in March of 2023, you had investigated this same vehicle, the 2015 Chrysler 300.
Correct.
And at some point, when you initially investigated it, it had parts in it that were determined to be part of another vehicle.
Correct.
But that, at that point in time, I would say, so those parts you indicated were removed from that vehicle, and it was returned, the 2015 Chrysler was returned to Mr. Purdy.
Correct.
So are we saying that the shell of the vehicle was returned to him?
Yes.
So it is determined that the shell of the vehicle, meaning the registration and the plate of that vehicle, belonged to Mr. Purnell?
At that time in 23, it was also registered to him. It was titled to Mr. Purnell in April of 2021.
Thank you for your recollection as it relates to those particular items. And so fast forward to 2024, May of 2024, you have an opportunity to investigate the same shell of the vehicle that's registered to Mr. Purnell.
Correct.
And you have determined that there are parts that were connected to this vehicle that were also stolen.
Correct.
And you rely on that based on the VIN numbers and other stamping identifications that are associated with those parts.
Correct.
And if I didn't ask, then I apologize. And those parts that was specifically, I believe you indicated, was the motor,
The transmission, the dashboard, the center console, the interior door panels, and the seats were consistent with the stolen car, the same trim pattern, same yellow stitching, but I could not positively identify the seats as being from that vehicle, but they were consistent with the vehicle and the other parts.
in your experience in the auto theft unit, as well as a Detroit police officer, and you are familiar with car enthusiasts, am I correct?
Yeah.
In terms of that, and car enthusiasts, sometimes change out the original parts for additional newer parts or parts that maybe make the car more exotic. Am I correct?
Correct.
And they also change out parts to make, particularly in this situation, you indicated that the original motor to this particular vehicle would have been a V6.
Correct.
And this was from the Charger was a supercharged,
Right. 6.2 liter V8.
which would have made the car one more exotic in terms of the aesthetics of it, looking at it.
Correct.
And it obviously made it more powerful as well.
Correct.
All right, thank you, Judge. I have no further questions.
Just, I understand this. You saw it, you saw the same vehicle in 2023.
March of 23, I identified the same vehicle, the whole vehicle.
And there were parts that were stolen in the vehicle at that time,
Correct.
and they were removed.
We had, the defendant paid to have the tow company remove those parts before we would allow it to be returned to him. He wanted his car back, but we would not allow it to be returned with the stolen parts still on it.
Okay.
So the tow company physically removed everything we told them to remove, which would have been the entire interior, the engine, the trans, and all of that was removed before it was returned to him.
The reason I just want to confirm that the stolen parts that you identified, in this case, they are not the same stolen parts that were identified in the 2023 matter.
Correct.
Okay.
Well, that car was stolen after I looked at it in March. The parts that I looked at this year were stolen in May of 23. The car was reported stolen in May of 23. I looked at that car in March.
Okay. Any further questions?
And that was just my follow-up question, Your Honor, was just to clarify, the 2022 Dodge Charger parts was reported stolen on what date, and you just specified on
That
May
was in May of 2020.
2023, Your Honor.
Correct.
And no further questions for the people. No further.
One more question. The items that you observed in the vehicle the second time, the most recent time, are these items if you, just in your experience, if you know the approximate value of items like this?
Well, as the motor, that's an expensive motor. That's 17,000 as the detective said. And the engine, the transmission, probably another 10. And then the dashboard is probably another with all the components, the entertainment center and the airbags, the steering column with the airbag. That's probably another 5,000.
Okay, thank you. Anything further?
Nothing further, Your Honor.
Mr. Taylor, any questions based on?
Can I have just one more, sir?
Yeah, of course.
Thank you, and I don't know, well, let me ask for a clarification so that I can understand this, based on this one, this three follow. What year was the charger before the stove? When was the
This one that I just looked at,
one that, the parts that you just looked at, when was that?
that was May of 23, I believe.
And again, you initially came in contact with the 2015 Chrysler, and when was that when you initially came?
March of 23.
And I believe you indicated that the parts that you saw in March of 2023, they were reported stolen when?
I do not recall, but that was from a 2021 Dodge Charger and not a 22 Dodge Charger.
Thank you.
No further questions. Your Honor.
Thank you, you may step down. May this witness be excused?
Yeah, thank you so much for being
Sir,
here.
you're all set.
Thank you.
Any further witnesses?
No further witnesses.
Defense?
Nothing from the discussion.
Arguments?
Your Honor, today, the people through testimony of Officer Jake Way and Detective Neckel have shown by probable cause standard that, number one, there was a crime of receiving and stealing stolen property valuing well over 20,000, and two, that the defendant, O'Leary Purnell, committed that crime. Therefore, the people ask for this to be bound over to circuit court. I will reserve any further argument for rebuttal.
Mr. Taylor?
It's an interesting set of facts, but the question is whether or not it's a question of fact. We both, and I know the court is well versed in these particular items and these situations, and what it boils down to is, particularly in this situation, is whether or not Mr. Fernando knew or had reason to know that the parts that were in a vehicle that he actually owned, because there's no doubt that he owned the 2015 Chrysler. The question becomes whether or not the items that were identified in May of 2024, whether or not he knew or had reason to know those items were stolen. I think the interesting part of this is that we know and understand that from Officer Jacob, that he had contact with his vehicle in 2015, in which basically it was legitimately registered to Mr. Purnell. And at that point, Mr. Purnell himself wanted the vehicle back to the extent that he paid Detroit Police Department and towing agency money in order to get the vehicle back. And it doesn't appear as if there was those parts that were taken that were identified as stolen from the 2021 Dodge were associated as to Mr. Purnell in terms of any type of criminality. We fast forward to May of 2024, and then it's the similar situation. He's with a vehicle that he owns, obviously operable with parts that have been identified as stolen or taken from the Dodge Charger, 2022 Dodge Charger. So the real issue, and I think where it does not reach to a probable cause issue, because in terms of this issue, as I asked the officer and relying on his experience in this situation, we know that there are car enthusiasts all over the country, all over the world, and that there are parts that are bought and purchased in order to for the aesthetic reasons and also the operation of the vehicle itself. And in this case, we know that the engine was a supercharged engine, much bigger than the original engine, and all the matching parts that essentially were that came from this Dodge Charger, that were identified that came from the Dodge Charger. But in essence, the fact that this is a registered vehicle to Mr. Purnell, and despite what has been identified, and there's no, I can't deny that these parts were associated with a vehicle that had been first stolen. But as a car enthusiast, as a person or a lay person or a citizen that's purchasing parts that we know that this car was basically disassembled, and he's purchasing parts to make the car operable, to change the aesthetics of it, and things of that nature. There's been no proof to show that he had reason to know or knew that what he was purchasing or what was placed in his vehicle at the time that those items were stolen. So from that standpoint, given the assembly of the vehicle, and we're talking about simple parts, and it becomes a question as a consumer, as a basic consumer, that Mr. Purnell, we can identify Mr. Purnell as a consumer, and if he's purchasing items for his personal use, particularly in this circumstance, and understanding what it takes to know and understand the stamping of the parts, like there's various different identifications as to whether or not he knew or should have known that what he was purchasing was stolen. So I would respectfully ask the court not to find this matter.
Briefly.
Briefly, Your Honor, respectfully, any issues defense counsel is presenting today, especially intent being a question of fact, would be for a trier of fact and circuit court to decide.
I don't disagree. So here's the challenge we run into. I have no information before me to suggest that there's any error of legitimacy in the items that he has. Now, whether or not this is all information that can come forward at trial or not, he also had information that Mr. Purnell, unfortunately, is very familiar with stolen parts, having had to incur the expense of having them removed from his vehicle previously. And in a short period of time, to once again have outfitted his motor vehicle with stolen items, I think that there's enough there to let the jury make the call. Whether the people can demonstrate that he should have known to a standard of beyond a reasonable doubt, we'll have to see a trial. But certainly for a probable cause, I have an individual who the same officer reviews the same car and he's got a whole new set of stolen motor parts in the vehicle. One would imagine that if Mr. Purnell is the savant you might suggest he is when it comes to appreciation for motor vehicles, that he would have been able to identify problematic parts and sources such to not allow that to go into his vehicle again. And yet again, we are here again with Mr. Purnell with a completely outfitted Chrysler 300 with stolen parts. To me, that's enough to get it to a jury, let them make the call. Matters bound over his charge.
Thank you.
Anything else for the record? All right. All right, Cameron Rye, 2400194.
Good afternoon, Your Honor. Samir Mamas on behalf of the people.
Good afternoon, Your Honor. Patrick O'Keefe on behalf of Mr. Rye, who's seated over here to my right. This is my paralegal, Emily Urbish, also seated to my right.
Rye, state your name.
Cameron Rye.
Today's date and time set for our continuing examination. This court broke the examination last time in hopes that there would be some opportunities for resolution. It seems like those did not go anywhere.
Well, Your Honor, for the record, I did take extreme measures to get a resolution, which I believe to be very, very fair. For the record, it would have been MDOP under $200, which is a delayed sentence to a dismissal with restitution of the cost of the fence was $1640. I did think that that's something that they wanted from speaking to defense counsel. When I presented the final offer, which was the offer I just stated to you, it was then declined yesterday. So,
Is that true, counsel?
Yes, it is, Your Honor.
Okay. Let's continue the examination.
so if I remember correctly, then, he was on, cross,
That's correct. So, sir, if you'll walk me through.
so. Okay, actually, come to this side. Thank you, Mr. Cole.
All right, please raise your right hand. Swear to tell the truth, the whole truth, and nothing but the truth, so help you God.
Yes, I do.
All right, please be seated.
Your Honor. Mr. Coleman, you're still under oath, you know that,
I
correct?
just placed him under oath.
Oh, I'm sorry. Mr. Cohen, the portion of the chain link fence that Mr. Rye removed from the property, at one point in time, was it not connected to another series of fences?
What should I be talking about now?
Well, Mr. Rye took down this portion of fence over which we're quarreling now, right?
He took down, yeah, he took down, yeah, 22 feet.
There's also a good portion of chain link fence that continues to surround Mr. Rye's property. Isn't that true?
There's chain link fence that surrounds all the properties there,
Okay.
even mine.
Well, so you have a chain link fence that surrounds your property?
Yeah, I had about a 30-foot piece that
Okay.
surrounded my property with Mr. Werber. We
Okay.
both agreed to get rid of the stumps that prevented it from coming out.
Okay.
And then,
Isn't it fair to say that you have a wooden fence that borders you and Mr. Rye's property?
no, actually, the part that 30-foot piece that was shared with Mr. Werber on my south neighbor had both of the chain link and the wooden
Okay,
fence.
but the portion of fencing that we're arguing about that was removed from the property at one point in time was connected to the rest of the fencing that surrounded Mr. Rye's property. Is that not true?
It was connected to the fencing that surrounded my property, his property, Mr. Werber's property. It was part of all the fencing that went down with all the neighbors.
Okay, so you acknowledge that that portion of fence connected with another portion of fence that surrounds Mr. Rye's property. Do you agree with that?
No, it surrounds all the properties. It's all connected.
Well,
That
sir, how can one fence line surround all the properties? What I'm asking is, the chain link fence that exists in Mr. Rye's property surrounds his property, and the section that was taken out was connected to that system. Isn't that true?
Was connected to, part of it was also connected to the system that was connected behind my property and then went down behind the Werber's property and the other property. It was all connected.
I have nothing further, Your Honor.
No further questions for the people, Your Honor.
Okay, you can sit down, sir.
Your Honor, we do have a stipulation that both of our expert witnesses are experts in the field of land survey. So we don't have to do broad air to qualify them as experts.
Okay,
And I think we also have a stipulation to the people's exhibits.
Yeah, one and two.
Exhibits 1 and 2, we stipulate for their admission without foundation. We've seen it. Thank you.
publish those. Thank you.
upon Matthew Compost to the stand. Matthew, come over here. Let's see.
Sir, please come to the chair. Before you sit down, raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, please be seated. And once seated, just state your full name for the record, please.
My name is Matthew Charles Kunkel.
And spell it, please.
It's MATTHEW CHARLES KUNKE.
All right, your witness.
Thank you, Matthew, for being here. Can you tell the court where you're employed?
I work for Wolverine Engineers and Surveyors in Mason, Michigan,
Okay, and how long have you been employed there?
since September of 2019.
Did you perform a survey in Berkeley, Michigan?
I did.
And that was on July 19th, 2023?
Correct.
What was the purpose of that survey?
The purpose of the survey was to determine the location of an existing chain link fence between the property of Mr. Cohen and the property of Mr. Cameron B. Hayes.
Okay, and so on that date, was there still a chain link fence up as you did your survey?
Yes.
And what were your findings?
I found at the northerly end of the fence, so the northerly-most fence post was 6 inches east of the property line onto Mr. Cohen's property. At the middle fence post, I found that it was 1 inch east of the property line onto Mr. Cohen's property. And at the southerly-most fence post, I found it to be on line with, or maybe slightly to Mr. Hayes's side of the property. I think I had 200ths on there, which is essentially nothing. It's
So let the record reflect, he's pinching his finger at a very minimal
200ths is about.
200.
So it's chain link fence post is 2.5 inches wide for perspective. So we're talking about this in comparison to a fence post that's this wide.
He says Hayes, does he mean Rye?
The fence post.
You said Mr. Hayes, you mean Cameron Rye, correct?
Or sorry, Cam, yeah.
I just wanted the record to reflect that there's
Sorry.
a reference to an individual being Cameron
My bad.
Hayes.
Okay, Cameron.
I just want to confirm that when you say Cameron Hayes, you're referring to Cameron Rye.
Correct. That was my mistake.
I needed, no, it's fine, I just need to
Thank
clear up
you.
the record.
I missed it. I apologize. Okay, so,
And I'm so sorry, now I was focused on that. Can you once again, just to make the record clear, explain where along the post, you said
Yep.
inches east, inches,
Yep.
can you walk through that one more time?
So there were 3 fence posts existing for the chain link fence. The southerly-most fence post, which was essentially right at the south property corner, was 200ths west of the line onto Cameron's property. So the 2.5 inch fence post was this far onto Cameron's property at the southerly-most point. At the middle fence post, it was 1 inch east of the property line onto Jared's property. And then at the northerly-most fence post, it was 6 inches east onto Jared's property.
so just to be clear, and as your expert opinion, it's mostly on Mr. Cohen's or on the line?
The majority of the fence was on line or on Mr. Cohen's property,
Okay,
in my opinion.
and on that day, did you put survey stakes
I-
to show
I did.
the property line?
Yep.
How many?
I put 1 at each end, so at the north property corner and south property corner, and I put 1 in the middle. Actually, I put 2 in the middle, because I put 1 at each of the other 2 fence posts that worked at a corner, so that they could see exactly how far each post was either way of the property line.
Okay, and did you, on that date, were both, or let me ask you, was Mr. Cohen there on that date?
Yes,
Did you explain your findings to Mr. Cohen?
yes,
And was Mr. Rye there on that date?
yes,
And did you explain your findings to Mr. Rye?
yes,
And then before today's hearing, I submitted you a letter, is that correct? From
Correct.
a surveyor hired by Mr. Cohen?
correct.
And, I'm sorry,
Hired by Mr. Rye.
I'm sorry, thank you, Mr. Rye. And on that, the surveyor, you have an opportunity to review that.
I did.
And did you find that that survey was different from yours?
I didn't find that me and the other surveyor disagreed. If he had performed his survey prior to me performing my work, I would have accepted his irons as the corners for Mr. Cohen's property.
Okay. Give me 1 second, Your Honor. No further questions, Your Honor.
Counsel?
Let's see.
No objection. Back to that, I'm not sure.
This is my house.
Yeah.
Back to that, correct. Okay. No issues.
Um, Your Honor, we have a slight evidentiary issue, and so my exhibits are coming in out of order. I'll move forward and by stipulation, we have an admission of defendant's proposed exhibits B as in Bosco and C as in Charlie, if I might approach.
You may.
First, Your Honor, if these are admitted, if I can show the witness first, then perhaps.
Yes, they're admitted by stipulation.
All right.
That's correct.
So
Thank
B
you.
and C, so right now I have people's 1 and 2 and defense B and C that are in.
Correct. Thank you, Your Honor. So, sir, do you recognize the photograph in defendant's exhibit B?
I recognize this to be the backyard of Mr. Rye.
Okay. And so, which portion of fence are we talking about when you testified that the majority of it was on Mr. Cohen's property?
We're talking about the portion of fence running from this fence post to the north along that line.
Okay, so can you highlight that in blue? You can just run it along the top post going to the left. All right, so now is that fencing gone now?
I have not been to the site to make any sort of personal, but from my understanding, that fence is gone.
Okay, so when you did your measurements, that fence was still there, correct?
Correct.
Okay, and then you mentioned that that a 6-inch, that I don't know, I don't want to misstate this, but you mentioned that one portion of the fence was essentially 6 inches onto Mr. Cohen's property, right?
Correct.
Would that be a portion that's depicted in this exhibit B?
No, so
Okay.
this post was the one that was 1 inch onto Mr. Cohen's property. There's another post that existed to the north of that, which is shown, is it in this picture? Yeah, this post right there is the northerlymost post
Okay,
that was 6 inches onto Mr. Cohen's property.
okay, so if we look at exhibit C, can
That
you
post.
circle that
Yes,
post, and then
absolutely.
I'll show it to the people. But if you can circle and then initial underneath it in the driveway there.
You made marks on another exhibit, will you initial that one as well?
Yep.
And date it, today's the 26th. Thank you, sir.
Thank you. All right. All right, so this section up here, then whose property is this? If we look at that post that I circled right there.
So a fence post, that post, the center of that post was 0.02 feet onto Mr. Rye's property, which is essentially on the property line
Right,
between the two properties. So a 2.5-inch fence post, that means that 1.25 inches was on one side and 1.25 inches was on the other side of the property line. So it's splitting the property line at that fence post.
okay. And now it appears that the fence posts themselves would have been on the inside facing Mr. Rye's property.
Based on that picture, I would agree.
Is that pretty typical when people put up a chain link fence, that they put the posts on their side of the property?
I don't have a lot of experience with fence building. I've put up a lot of stakes online for people to build fences, but I don't have experience with how the fences are built.
All right, so this portion here that you circled, can you initial that as well?
Oh, yes.
And then date that as well
Yeah.
for his honor. Thank you. Okay, and then you said 0.022
The
inches
center onto
onto
towards
rise,
rise side.
on rise side.
0.02 feet, which would be quarter of an inch.
Okay. So 0.02 feet on rise side, right?
Yep.
Does that accurately represent what you just testified to?
Correct.
0.025, 0.02 feet on rise side. Okay.
Correct.
Can you initial that as well? Okay. Thank you. And then if you could just draw a line from the top of that post line to the diagram. Yeah, there we go. That's good. Thank you. Okay, so then if we look at, if I might have, here, I'm going to show the council. He's got marked up. Okay. That's all right, thank you. So thank you, Your Honor. So if we were to essentially summarize your testimony, what you're essentially saying is that whoever built this fence built it in such a way that they didn't measure very accurately. Isn't that true?
I guess I don't really know how they built the fence.
Is that gonna cause for speculation?
If he knows.
So,
If he knows, he can answer, if he doesn't.
sorry, could you repeat the question?
Well, I mean, they're off by a half foot.
Right.
So
A lot of times people build fences without permits, without surveys,
right.
somebody might not have measured anything to build a fence. It might have just been built next to another fence that was already there.
Right.
So things get kind of weird with fences if people don't go through the right channels all the time.
Sure. And do you know whether or not the city of Berkeley even required a permit to build a fence 50 years ago?
I have no idea what the requirements now for the city of Berkeley are for fences. So
You might know Mason, not.
it's really not part of my expertise.
Okay.
So it's really more for the fence people. I show them where the property lines are and they make sure they don't go outside of them when they build the fence.
Okay. This appeared to be a very old fence. Would that be fair to say?
Yeah, I would say it was an old fence. I don't have a way to estimate the age. Chain link fences are some of the harder fences to estimate the age of, especially if they don't weather, if they're, the stainless steel takes care of itself over time, they don't get. So it takes a long time for a chain link fence to age as opposed to a wood fence or something like that, where you can really tell the age better.
All right. But essentially, if we were to look at Exhibit B, it's 0.02 feet onto Mr. Rye's property. And then it extends down, and at the other post, at the other end, it's 6 inches onto Mr. Cohen's property, correct?
Correct.
Okay, so would it be fair to say that whoever put that fence in did not survey or did not do an accurate survey?
Yeah,
Before
yes.
they put it
It would
in.
be fair to say whoever built that fence probably was not going on a survey.
So for all we know, it could have been just a couple of guys, a homeowner and a case of beer and his buddies, and they throw up the fence,
Could have been anybody, yeah.
right?
Yeah.
Okay. Do you have any knowledge as to who purchased the fencing in question?
Nope.
Do you have an opinion as to whether or not this particular section of fence tied into another section of chain link fence?
I think that the chain, so the posts were still there, but the chain had already been ripped off, so it was kind of hard to tell, but I believe that the post went to the west from that southerly one.
Okay,
That the chain, it tied into a fence that was heading to the west,
okay.
if I remember correctly.
So we're all bad with directions.
Because if we're looking at the picture, I think the picture shows that the top rail of
This
right
is,
here, it kind of, or are those two posts? Yeah, it kind of ties in, but there's like a jog, so
okay. So,
it's not it doesn't look like the fence was necessarily, like this section doesn't look like it was necessarily constructed at the same time as this section because of the jog and height, but
okay,
that's just looking at it.
okay,
But they are tied in together.
okay.
Obviously, this fence tied into that post, so.
All right, and so we're clear. If we could perhaps retrieve exhibit B, Your Honor, I can have him highlight. B? Yes, B, thank you. So if you could just highlight the portion of the fencing that you're referring to that was formerly tied into the section that was removed. Okay. You can initial, maybe over the dirt where here, I got a pen. Yeah, I probably should.
Kind of this.
Thank you. Yeah, I don't know how long that highlighter's been in my briefcase, but it's on its last legs. All right, thank you, sir. All right. All right, so the two sections you highlighted, would it be fair to say they surround Mr. Rye's property?
That would be fair to
All
say.
right, thank you. I have nothing further. Your Honor, there's exhibit D back. Thank you. Highlighted extra portion. Thank you.
No further questions.
Okay, just stick down.
Thank you. Appreciate your time. Briefly call Detective Stafford to the stand.
Please approach the stand.
Someone can go. Yeah, sorry.
Or tell the truth, the whole truth, and nothing but the truth, so help me God.
I do, Your Honor.
Right. Detective, if you please state your name, spell it for the record, please.
Brian Gothard, B-R-I-A-N, last of G-O-T-H-A-R-D as in David.
Your witness.
Thank you, Detective, for being here today. Where are you employed?
Employed for the city of Berkeley,
And how long have you been a detective with the city of Berkeley?
just over a year.
Were you assigned to a case on July 24, 2023 involving Cameron Rye?
I was.
What, if anything, did you find during that investigation?
During that investigation, I was assigned the case on the 24th. I began to look at it on the 27th. As I was calling Mr. Cohen to check with him to set up a time for an interview regarding the case. I heard officers dispatched to Mr. Cohen's house for another neighbor trouble involving the fence.
Was that at 2575 Village Ave, Berkeley?
It was.
And what was the nature of that dispatch?
Nature of dispatch had to do with a fence that was actually taken away. It was missing.
And did you arrive personally on the scene to do your investigation?
I did. When I read that scene, PSO Cormier, PSO Smith were already engaged in talking to Mr. Cohen. So I listened in, and then since it was my case, I started investigating myself.
Okay, what did you find?
I found Mr. Cohen had pointed to the back where the fence was no longer there. I saw Mr. Rye in the backyard, began to ask him about the survey stakes that were placed by Wolverine. He admitted to taking them out because they were on his property. When I went to question him some more, he didn't really want to talk, became a little hostile, walked away. I did determine that Mr. Wright did admit on camera that he did move the fence posts because they were on his property.
Okay, so just to be clear, you made contact with Mr. Rye, and he admitted to you that he did remove the stakes in the fence?
That's correct.
Did Mr. Rye state to you whether or not he knew that a survey had been completed on that fence?
That I cannot recall.
Okay, no worries. And what, if anything, was put on the property line after the stakes were removed?
I believe Mr. Wright pointed out that he had pulled a string from the iron that was set by Wolverine to a new stake or new place that he put near the sidewalk. out of the fence line was.
Just to be clear, he attempted to make essentially a new line?
Correct.
And during your investigation, you obviously interviewed Mr. Kunkel, the surveyor.
Yes, I did. I thought.
And you did get estimates from Mr. Cohen as well.
That is correct.
Did you do anything else during your investigation?
No, I just looked at the survey, wanted to make sure that the fence posts were definitely on Mr. Cohen's property for pursuing the case.
No further questions?
Council,
Small area.
that's fine.
Oh, okay. So, Detective, there were stakes still in the ground when you went out to investigate the property, isn't that true?
If I recall correctly, it was not. I'd have to look at my photos, but I do believe the stakes were pulled out and next to the garage.
Okay. Was there a string that connected any stakes that you observed on that property?
I believe there was a stake that was buried in. It wasn't high like a normal stake, and it was connected, I do believe, to the iron that was placed by Wolverine on the south side of the properties.
Okay, but there was a string connecting those stakes, isn't that true?
Yeah, but I believe Mr. Rice said he was the one who put the string up, so I couldn't go by. I'm going more off the survey than what the string said.
Did you actually view the property and with your own two eyes?
I did.
So you went on the scene to look at the property in question?
I did.
Okay, and the fence was gone, right?
The fence was gone, that's correct.
But are you testifying that there were still some stakes on the ground?
There were not stakes in the ground. The stakes were pulled up and then next to Mr. Cohen's garage.
Okay. Do you know who bought the fencing in question?
I do not.
All right. If I built a fence today, would I need to get a permit from the city of Berkeley?
That I don't know. That would be through the building department, not the public safety.
So during the course of your investigation, you discovered that this was a property dispute, correct?
I didn't look at it as a property dispute. I looked at it as a malicious destruction of property. Somebody took a fence away that was no longer there without permission.
Okay. So someone that took their own fence out wouldn't be a malicious destruction of property?
If it was his own fence, no.
Okay. So you essentially took Mr. Cohen's word for it, that the survey proved in your mind that the fence belonged to Mr. Cohen, isn't that true?
I looked at the survey and then conferred with Mr. Conkle from Wolverine to confirm the findings that the one post was 6 inches onto Mr. Cohen's property, the other was 1 inch, and the other one was, I guess, adjoining all the properties.
Sure, okay. Being unfamiliar with the permitting process, did you do any attempt to investigate the permitting process to determine when that fence may have been put in?
I did not.
So you're assuming that the fence was Cohen's because it was on Cohen's property, is that fair to say?
That's what I went with. Yeah, I went with the survey that was filed with the county, correct?
Okay. All right, and the survey that was filed with the county, do you mean Mr. Kunkel's survey
Yes,
that was just done this past year?
correct. Or no, not this past year, it would have been last year.
Last year?
Yes, correct.
That's what I'm.
July
sorry.
23rd.
Confusing question. All right, thank you, Detective. I have nothing further.
All right, Detective, any follow-up?
No
You may step
problem.
down.
Thank you.
Thank you, Detective. People rest, we have nothing to this.
Council?
Thank you, Your Honor. At this time, the defendant would move for the admission of defendant's exhibit A. This is an affidavit that was generated by Donna Bell. And I provided the people a copy We are moving to admit this exhibit under Michigan Rule of Evidence 1101B8, which states that the rules of evidence are not applicable in preliminary examinations where property matters are concerned. And it states that at a preliminary examination in a criminal case during which hearsay is admissible to prove the ownership, value, or possession of, or right to use or enter the property. So even though counsel correctly points out that this affidavit is hearsay, hearsay would be admissible under Rule 1101B8, because this affidavit relates directly to the ownership of the fence in question.
Your Honor, I will keep my objection. I don't know how this could prove ownership.
I guess what's the offer of proof? I haven't seen the document.
Well, I'll approach you on it. That's easier.
The question is why.
If I may add, she's discussing that she shared a chain link fence with Cameron. But I just don't know how it's to prove ownership of this specific fence between Mr. Rye and Mr. Cohen.
I guess counsel, Ms. Bell's affidavit indicates that the fence is around Mr. Rye's property, but there isn't a portion of this that says I was there when it was built. It was always agreed upon that this was the line. I mean, there's nothing specifically about this area of fencing, this particular portion of the fence that talks about ownership or entry, authority to use. Just, I guess, a fact that she's observed, and you think that observation falls under that umbrella, so it need not be tested via cross-examination, that it could just be accepted under this portion of the rules of evidence. I guess, counsel.
Well, if we look at Defendant's Exhibit B, the portions that were highlighted by Mr. Kunkel today were the portions of fence that were in existence before Mr. Rye removed that portion of fence. He testified that those fences tied together. Ms. Bell is stating under oath in her affidavit that she's lived in this neighborhood for over 40 years, that she shared a chain link fence with Mr. Rye, and that for over 40 years, this chain link fence has surrounded Mr. Rye's property, which would create a reasonable person could infer that if a fence surrounds Mr. Rye's property for the last 4 years, that it is in fact his fence, regardless of where the fence is situated.
I guess the argument would be that she shares a chain link fence with Mr. Rye, so does that mean that her fence is his fence too?
Apparently, at least a portion of it.
So that if he wanted to remove her fence, he could? Because if the idea is to establish that this is Mr. Rye's fence all the way around, I guess I would expect something from Ms. Bell to say, this fence that's around his property is Mr. Rise. It's not Mr. Cohen's, it's not mine, it's Mr. Rise. Now, but to the prosecutor's point, I mean, it's a preliminary examination. I don't know that it neatly fits under this, but at the same point in time, the court can give whatever weight it chooses to. So I don't necessarily have an issue with counsel introducing it at this time. It is, I guess, a factor that the court could take a look at in the course of evaluating all the testimony related to ownership. I see it that it has limited evidentiary value, but I'm not going to prohibit him from producing it. So the exhibit is admitted for what it's worth.
Thank you, Your Honor.
Thank you, Your Honor.
With that, we will call Michael Ty.
Raise your right hand. Swear to tell the truth, the whole truth, and nothing but the truth, so help you God.
I do.
All right, please be seated, sir. Once comfortably seated, if you could please state your name and spell your name for the record.
My name is Michael Frederick Ty, Lichael, Frederick, Frederick. Ty is Tighe.
Thank you, sir. Your witness.
Mr. Ty, you are a surveyor, correct?
I am
And where do you currently reside? What city?
Berkeley,
All right, how long have you lived in Berkeley?
over 71 years.
Over 71 years?
Yes, sir.
You're very familiar with this, this area of property that we're discussing here today, isn't that true?
Yes,
Okay. Did you yourself or have any relatives who at one point in time lived in this area, this neighborhood in Berkeley?
well, I grew up on Phillips, which is south of Mr. Cohen's, between 11 Mile and Cambridge. My parents moved in there in 1943. I was born in 1950. And then I got married, moved out of the city for a couple of years, and I moved back in with my wife, and we bought the house on Catalpa in 1972. That was between Bacon and Cummings. It was on the north side.
Now, Catalpa and Phillips, those are a couple of streets that are mentioned that are very near Mr. Cohen and Mr. Wright's property, correct?
My house that I bought, 72, was about 200 to 300 feet from Mr. Cameron's property.
Okay, so you said you bought that house when?
1972.
Okay, and do you know Donna Bell,
Yes, I do. She's a good neighbor.
the applicant in Exhibit A?
Pardon me.
She's the applicant in Exhibit A. I'm just providing that for the court's clarification. So, Ms. Bell has indicated in her affidavit that this chain link fence has surrounded the property that Mr. Wright now owns for, she says, over 40 years.
She is correct.
She's correct about that? Okay. So, and we're talking about a portion of the fence that Mr. Wright had removed, isn't that true?
Yes, it is.
All right. And then you conducted your own survey as well, correct?
That is correct.
Okay, and I'm going to move for the admission of defendants exhibit D as in David.
Any objection?
No objection, Your Honor.
May I approach you?
You may.
Thanks. So I think what I'll have you do, Mr. Ty, is I will have you highlight where the fencing was around Mr. Wright's property. Would you be able to do that on that copy of that survey?
I can do it on anybody's survey.
All right. So I think what I'll do is I will. Is that admitted, Your Honor?
It's been admitted.
Okay.
They agree to it.
All right. I just have an exact copy of it that I'd like to show Mr. Ty. I hate to take it back from him. So can you take this highlighter and just basically highlight the fence line that we're talking about? Because you're saying that this system of fencing had surrounded Mr. Wright's property, correct?
Correct.
And that the portion that was removed at one point tied into the fence that bordered on Mr. Wright's, not Mr. Cohen's property, correct?
I was on Mr. Wright's property, yes. You want me to circle this or?
Well, can you draw a line, can you just highlight it with that blue highlighter about, where, we're talking about, because it's really hard to see, there's so many different data points on there.
That's the section of fence we're talking about,
Okay,
20.2 feet.
and then, okay, so that's, can I borrow your highlighter? Oh, yeah, I'm gonna use, I'm gonna go green, is that okay? Yeah, that's what happened. All right. Okay, so now with this nifty green highlighter, can you highlight the remaining portion of the fencing that was not removed, that's still on Mr. Rye's property? Okay, and it shows that fencing ends where it says existing 1.5 story vinyl with basement, house number 2576. Whose house is that?
This one here, 25, or this is Cameron's.
Okay. Can you just write in there in that box, Rye's house, please? And then the court would like you to initial and date that as well. Today's the 26th of July. Just don't, over here is fine, just underneath the house number. 26, yes. Okay. Okay, is there any other fencing that goes around Mr. Rye's property?
No, that's it. Well, actually, that's not correct. He's got a vinyl fence over here, 6-foot high vinyl fence. It goes along the telephone, comes off of his house and goes back on an angle to his driveway, and then comes into this northwest corner of his garage.
Okay, so there's a vinyl fence on the other side?
Yeah, on the north side.
Okay, so is the lines you drew in green and in blue, what does that represent just the chain link portion of the fencing in question here?
It does.
Okay, thank you. And so just give us kind of a broad brush here. What did you find with respect to, thanks, Shannon. With respect to that highlighted blue section that was removed by Mr. Rye, what were your findings in your survey?
Well, I gave him a proposal and the fence was still up, but when I gave it to him, and then after that, a couple weeks later, I drove by and the fence was gone. So everybody was saying that the whole fence was removed, and I talked to Cameron and he told me, no, there's posts down in the ground. So we found the existing posts down in the ground where the fence posts were broken off at, below ground level, about 6 to 8 inches below. And I know that the one corner post was about 15 inches encased in concrete still there. And the other one was 18 inches long encased in concrete. And then the gentleman that works with me, we located those, and we also located the corner of Donna Bell's fence corner.
Okay. And Donna Bell's fence line, would that be the fence that she shares with Mr. Rye?
Yes,
Would that be the green highlighted portion of the fence?
it would be.
Okay. And which way do the posts face on the fencing system? The chain link?
On Donna's or on the other one?
In Rye's?
It faced to the east.
What does that tell you?
Well, the old saying is that, and what they go by now is that if you put the wire up, that's the property line, and that's generally how they view it. And I've worked with many fence companies, and I've actually laid out fences myself, and that's how they put them up.
So the majority of landowners are gonna try to put the posts on their side of the property, right?
Well, actually, there's rules now that if you put the fence up, you have to put the bad side to you so that the neighbors have the good side, which in this case would be the actual wire. If it was a wood fence, you have to put the good side of the wood fence towards the neighbor.
Towards the neighbor,
That's the rules they have now.
the good side toward your neighbor, the ugly side toward you.
Yes, sir.
What were the rules like in 1985?
There wasn't a whole lot of rules back in '85.
Okay, Mr. Kunkel testified that, this portion of fence was 0.02 feet onto Mr. Rye's property, and at 1.6 inches onto Mr. Cohen's property. Do you agree with that?
I don't agree with his numbers because I disagree with his survey.
Okay,
So my findings is that the furthest point north was 5 inches over to the center line of the post. And then I found the other one down, and that was roughly an inch, I believe.
so are these like, you talking about the original chain link fence posts?
Yes,
That were still on the ground?
yes, sir.
And you say, how much of it was on Mr. Rye's property?
Well, I can look at my drawing here and I can show you if that's all
Do
right.
you have a copy of it?
I got it right here.
Sure, it's been admitted. You have a copy of this?
I do not think.
Where it starts out at the corner of Donna's property. Part of that fence was on Donna's property because that fence post is not on anybody's property but Donna's. And then it comes up to the north and it goes to the first fence post that I found. And that post there is the westerly edge of that fence post would intersect with the property lines of Cameron's and Mr. Cohen's property. Then at that point it bends and it goes to the east and it goes another 9.3 or 5.3 feet. And then that one is over about 4,300, which is roughly 5 inches
On the whose property?
onto Mr. Cohen's.
Okay, so would it be fair to say that your findings were that this fence at one juncture was on Mr. Rye's side of the property?
Yes,
And at another juncture, that same section of fencing fell onto Mr. Cohen's property?
that'd be correct.
And what would your opinion be as to the placement of that fence?
Well, since I've lived in Berkeley a long time, I know and see these cities down here got a nickname of being a good old boy cities. They didn't have many ordinances, they didn't have many rules. They just came in and, like you said before, that they would get, they talked to the neighbors, most of the neighbors got along. So you go out and get a case of beer and put the fence up and then they were happy. They didn't have any surveys or anything like that.
You bought that house back in, let's say, a couple, 2 years ago, which would be reasonable for you to think that that portion of fence was yours if you bought Rye's house?
Well, it depends, see, because I'm a surveyor, so I wouldn't buy a house without knowing where the property lines are at.
Now, we've already admitted defendant's exhibit B. And do you recognize that photograph?
I do.
What is it?
That is a copy of the fence between Cameron's and Mr. Cohen's property, or approximately on the same line. And then the other one was at Donna's corner, and it went to the.
This is Donna's?
Yes. And
Okay, so
then-
Your Honor, the green line in exhibit B is Donna Bell's post.
And
She shares it.
that fence went to the west towards Bacon Avenue, and then also went south along the rear lines. Theoretically, that should be the corner of the four property corners there. But it's not put in the place where it's theoretical. This is
Okay.
because it wasn't ever staked out that way.
Okay, so where is that section of fence next to that utility pole?
Actually, I
Where is that
show,
located?
that being 1 inch to the south of what I surveyed for Cameron's property, and 2,300, which is roughly about 3 inches to the west of Cameron's property.
So that fence post there
Mm-hmm.
to the right of this utility pole, exhibit B,
Yes,
is on whose property?
it's on Donna's.
Okay,
Most of it is. There's a little bit that's not, but most of it's on hers.
what about the fencing that extends from that post? That vertical post that's next to the utility pole?
The fence post right there,
Yes,
that's just the corner post is in the case where most of the people got along, they said, sure, use it, tie into it, no problem.
Okay, well, so we drew a blue line on that fence post in
Correct.
exhibit B. It's not on this, it's on the
Correct.
latest copy. Whose property is that section on?
This section right here?
This section right here. Yeah.
The first section of, it goes on Cameron's property. And if you take and run that up from the pole and intersect it, with the bearings and things like that, it shows that to the center of the fence from the back property corner is 7.71 feet, which is the center line of the fence. But that section of fence is 10.51 feet. And if you go to that fence post, which is the angle point, that westerly edge of that fence post is 200, which is a 1/4 inch on Cameron's property. So basically that fence is mainly all on Cameron
Okay.
for the first section.
What about this wooden fence here that's on the other side of that chain link fence that is now removed?
Okay.
What can you tell us about that?
Where we set our point, we set it in the underneath of the fence in the center of it. So
Again,
it's an encroachment.
we're referring to exhibit B. So we're talking about the wooden fence depicted in
The
exhibit
6-foot
B.
high wood fence, yes.
Yes,
Now that fence comes up and also goes south of the property about 1 foot. And then it comes up and there's an encroachment on that about 4 inches. And then that fence bends and comes up to the other 6-foot high wood fence. And that's over about 3 inches.
so this wood fence belongs to Mr. Cohen.
Yes, sir.
You're
Except for
saying-
that little portion of about 4 inches that it's an encroachment on both.
Okay, so you're saying that a portion of Mr. Cohen's wood fence, which is adjacent the chain link fence that was removed, is actually on Mr. Rye's property.
Actually, just a little bit of it is right where it starts, but the rest of it is all on Mr. Cohen's.
Okay.
That wood fence is.
Okay, all right. So there's a portion of, a small portion of the wooden fence that's on Mr. Rye's property.
Correct.
And then the majority of it, the large majority of it is on Mr. Cohen's property.
That's
where it
correct.
should be. Are they supposed to have 2 fences back to back like that?
A lot of people do different things like that. There wasn't any rules to do that. Now they got some rules coming in, and if you put in 2 fences like that, say there was a chain link fence existing, now they make you, if you go and put another fence in, you have to keep it up 6 inches so people can get underneath and start weeding and everything else.
Okay. And this exhibit B, I think, pretty obviously demonstrates the issues you have with foliage and weeding and a couple
Yep.
stumps getting,
Well, yeah, there was trees and things there, and that fence right there, that wood fence is probably 30 years old. So if there was any vegetation under there and they started doing some landscaping, cleaning and everything else, and if they pulled on some, it's very possible they could have broken some slats on that board, on that fence.
Mhm. Okay. Small,
Fine.
nothing further.
Just a couple of questions. Just to clarify, you stated that customs back in the 1980s could very well be different from customs that we talked about today, is that correct?
Oh, yes.
And you testified, you're not debating that the fence is either part of the fence is on Mr. Rye's property and part is on Mr. Thorne's property, is that correct?
Yeah, it's about half and half is what it is.
No further questions, Your Honor.
When did you do, I have a date on this survey, it says May 3rd on this particular survey.
Mhm.
Did you do any other surveys?
I got another one right here that I'm reading off. I did some revisions on some of this. And I took it up to, and I put it on a legal size paper. I took it to Oakland County Register of Deeds and I recorded it as July 11th.
July 11th of this year?
Yes, sir.
When's the earliest that you did a survey of this?
That would have been that survey.
May 3rd of 24?
Yes, sir.
All right.
And the reason why it's on a bigger sheet of paper, because Cameron and his dad said that they couldn't read the other survey very well, and I understand it. I said, yeah. And I said, what would you like? I says, I can make it bigger, like that one there, an 11 by 17 size sheet of paper, so you can read it. I says, but you can't take that to the county and record it at the Register of Deeds. I'd have to go put it on legal documents, which I did on these here, and I put it on 3 sheets because there's so much detail. You have to make sure you do that.
Thank you. Any follow-up questions based on what I asked?
Not for the people.
No, you're right, thank you.
Sir, you may step down, your excuse.
Thank you.
Thank you, sir.
Council.
Thanks, Your Honor. So just wanted to make sure we admitted exhibits A, B, C, and D.
Yes, although I would actually advise council to, I have two Ds, and one of the Ds is marked up. And so perhaps the exhibit D that's marked up would be better referenced as exhibit D.
Yes, I agree. I can take the other D back, Your Honor, just to avoid confusion of the record.
I actually don't have a problem. We have defendants A, B, C, and D. If you want to remark this one as E, I'll still keep it as part of
Oh,
the
no,
record.
I don't have any. That's fine.
That's what I'm saying. If you don't have an E, we could just change this one to E, the one that's marked.
Okay,
I have an unmarked copy.
I was just gonna say, I'll take the unmarked copy.
Okay, that's fine. We'll keep this one then.
Thank you.
So I have defendants A, B, C, and D, and I have peoples 1 and 2.
That's fine.
All right.
Thank you, Your Honor. We have nothing for there. Thank you.
All right, any rebuttal?
This is my closing, Your Honor.
All right, go ahead.
Your Honor, heard testimony at the last preliminary hearing and continue today that sometime between July 20th and July 21st, 2023, Cameron Rye removed the chain link fence and post located between his home and Jerry Cohen's home after both him and Cohen had been disputing over a property line. Mr. Cohen followed the order of the Berkeley Police and got a survey done, which he paid for solely. Mr. White was aware of the survey and admitted to the officers that he removed and disregarded the fence that was on the property line, even though he stated that the surveyor put the stakes in. He simply just didn't agree with it. He took it upon himself to remove this fencing and also admitted to Detective Docker that he did remove the fence as well. He didn't attempt to get his own survey done prior to maliciously destroying the fence and removing the stakes on the property. Your Honor, ultimately, it's a question of fact of whose property line it is. But Your Honor, the people believe based on the evidence today that we have proven by a probable cause standard that there was a crime committed, that he did commit that crime.
As to value, counsel?
Yeah, and as to value, Your Honor, we did provide testimony that it is over $1,000, but less than $20,000. The exact amount was $1,640 for the chain fence replacement.
Counsel?
Your Honor, I would simply point out to the court that the people charged Mr. Rye with destruction of personal property of another. And the complaint states that Mr. Rye did willfully and maliciously destroy or injure fence posts. There was no indication that he destroyed any fence posts. Fencing and survey markers, I don't believe there was any indication that those fencing or the survey markers were the personal property of Jared Cohen. Moreover, they've alleged that the amount of destruction or injury of the property was $1,000 or more. Now, the value of the property is not the value of what it would cost to have the surveyor come back and resurvey the area. Civil remedies remain, and it's my understanding that there is a civil case ongoing between the two parties. But there is absolutely no evidence whatsoever that this fencing, whether it be the posts or the fencing or even the survey markers, were the personal property of Jared Cohen. That is what the people have to show. They have to show that the fencing itself, the posts themselves, the survey markers were all the personal property of Mr. Cohen, and the destruction or injury was $1,000 or more, but less than $20,000. Now, if we look at Defendant's Exhibit B, we can see that Mr. Cohen has a wooden fence, which is adjacent to the chain link fence that bordered the two individuals' property. And the section of fence had brush, it had weeds, it had stumps growing in between it. And moreover, Your Honor, I can't frankly understand why Mr. Cohen is so worried about having this fence up around the property, except for the fact that he just simply wants to have a dispute with my client, that he wants to obtain money from my client. And, you know, he still hasn't come up with a good reason why he wanted to keep this piece of junk fence, other than to sit there and squabble with my client over where the property lines are drawn. It really doesn't matter where the property lines are drawn. This fence was clearly not installed by Mr. Rye. Mr. Rye purchased this home, and Mr. Rye would have had every reason to believe that this was part of the fencing that surrounded his property. So, I mean, common sense says it's Rye's fence. The people, moreover, have provided no evidence that Mr. Cohen had owned any portion of this fence, none whatsoever. And because of that, Your Honor, the case must be dismissed.
Stated briefly, these are all questions of facts for a jury or a judge in the circuit court to decide, so I again ask this be bound over.
So the challenge that we're running into is that I just caution counsel to remember that this is not a trial. This is a probable cause hearing. This is simply to decide whether there's enough evidence to send this to trial, whether there's enough here that could go in front of a jury and a jury could see things one way or the other. In fact, there's case law that suggests that if a court has evidence both supporting and negating an element, I am duty bound to send this up to the next level. Before I make my ruling, however, I just want to just confirm with you, counsel, one more time, that you have made Mr. Rye fully aware of the plea offer that the people made of a reduction to MDOP less than 200 pursuant to 771. The terms of that would be 100% up to me. And I can state clearly that my terms would be quite limited on this. I guess there was an agreement as to restitution. That would be what you'd be looking for, right?
It would be conditional on restitution.
So basically, my feeling after hearing the evidence in this case would be if he wanted to take advantage of the people who still were offering that before I made my final bind-over decision, that the grand total would be, of his terms would be a 6-month non-reporting, no criminal behavior, pay full restitution, and he would be able to earn a dismissal. That's where I'm at. So I don't know if having the additional facts of what the court would be willing to put forth as a potential term of a delayed sentence is worthy of you having an additional conversation with your client before I make my final bind-over decision.
It is, yes, Your Honor, because when I spoke to the people, they were under the impression that it'd be an 11-month delay.
Well, that's because delayed sentences in general are 11 months.
Yeah, and Your Honor, if I may add and maybe meet halfway, I do want some monitoring on this case just so there's to avoid any future issues. But I'm okay with the non-reporting.
Well, basically, a non-reporting probation, we still, no new criminal offenses. I guess I could throw in there, no, I trust these individuals aren't having contact with one another anyway. Correct, counsel?
Correct.
Okay, so no contact with Mr. Cohen. And then to me, if there's still pending civil action, so if something's gonna flare up, it would probably happen in the next 6 months, which would still be on my watch. And then full restitution would be available. This is something that, it should be a circumstance where the police department is going out constantly and having to try to manage this. Where Mr. Rye is facing, if he gets the wrong jury, facing a potential felony. I would hate to have that type of circumstance come down. Where Mr. Cohen has his rights that are protected, and in the end, it would seem to be an opportunity. But that being said, I just want to make sure that Mr. Rye, before I enter my final ruling, has had a chance to contemplate the additional information that the court has provided. And if the people have any problem, or if the police department have any problem with what the court has just put forward, please say so now. But boy, I would hate to send this up to circuit court knowing that we missed a moment to try to resolve this. So do you think it's worthwhile at least having a conversation or not?
Well, I just had a moment to confirm with my client, and You wrote no deal. on this.
Okay.
That works for us.
That's
I
fine.
think
This
we're on the
matter is
same
bound
page.
over to Oakland County Circuit Court for further disposition.
Thank you.
Thank you. 301481 Ariel Hodgson.
Good afternoon, Kyle Peskovich, area land people.
There's something that's not on that.
Ms. Hodgson, state your name. Today's date and time set for, well, at this point in time, it was set for a review. There's been some new allegations that have come forth. Mr. Smith, realizing the incredibly short amount of time that you would have a chance to take a look at these things, the court was not inclined to set it for a violation today, just so you know.
I've already looked at it, I had it a while ago, I had all the messages.
So there's new, looking at this.
Those are just screenshots, and I was aware that there was some screenshots. I'm ready to do it, I'll wait as long as you want. Like to, I don't think this is a violation, that's gonna be my argument. I'm not disputing that anything was, I'm not disputing anything was said, I'm not disputing anything at all, I just don't think it's a violation. I'll call one witness and he'll testify to what he told Alvin, and they'll make a decision. There's no more than, I can stipulate to all of this stuff, because it's a fact that it was said.
So, just so I can walk through this, so it's my understanding that people are alleging, at the time of sentencing, the court instructed Ms. Hodgson to not any direct or indirect contact with a number of people. And one in particular being Ms. Caroline, last name Oberst.
Yes.
And the allegations from the people are that, at least that's to my understanding, I don't have screenshots, I don't have this information, but that from jail, she provided some direction to her husband to relay information to this Alvin individual, information that would would generate a reaction such that would cause some type of issue or contact with Ms. Oberst. Now, there are a number of layers to this, but as you can imagine, I've been at this a long time. I know individuals who try to get to people. I know that there's direct, and then there's very complicated and I guess well planned out ways to get to someone through others. Now, I don't know if that's what the people are ultimately alleging, that Ms. Hodgson in the end used her husband and this Alvin individual to get to Ms. Oberst. That seems to be what the allegation is, correct, Mr. Peskovich?
Yes, Your Honor, that is the crux of it, but also there were screenshots from the defendant's phone sent to Alvin Spencer on June 22nd, 2024 from the defendant's phone. That's the day the defendant got out of jail.
Okay, so now this is taking her husband out of the sort of out of the line of
That's the
this effort.
second piece to it.
Okay. All right, so
And my one witness will justify that he's the one who sent these to Alvin, because Alvin broke up with this Caroline, who was a witness, protected witness, because you put her on no contact. It's actually in a separate section than the actual complaints in the case, but I think it's pretty clear that.
I mean, I can pull up her sentence.
Yeah, it's pretty clear.
I mean, it's pretty clear.
It's not a real issue. The only issue is this a violation in light of what Dan is going to say about what he did in respect to relaying information to a man who reached out to him after he broke up with Caroline. Again, this is like Jersey Shore kind of stuff. It's silly, but it could be construed as a violation. I don't think it is a violation, based on what I know. And I think it will take me 10 minutes to discover that. And I'll stipulate to these items I've already had access to for a number of days. And this new stuff will come in. I have no problem with that, because in fact it was sent by my client's husband. And my question for the court will be, is this communication with the caveat that my client's husband said, by the way, do not relay any of this to Caroline at all? Is that a violation? Because that's what he said.
I guess the court will have to make that determination.
They had a full conversation with your probation officer, Dan did, I guess, in the last day or so, telling you all of this. There's some.
That's part of in the workup for hearing worksheet, that's one of the allegations as well as making an untruthful report to probation officer.
Well,
I
expected this
I know you have an exam,
Yes.
just set up,
and we're gonna go into the exam, so,
if I can take the whole afternoon.
it's gonna take the bulk of the afternoon. So I would invite you to have more conversations with Mr. Pasculovich. I am here, I'll be here for a while, I have no problem managing this after the examination, or if there's some other specific date that's selected, it doesn't matter to me, but I would invite you, Mr. Pasculovich, to have some additional conversations about this with Ms. Linke, and see if we can make it as streamlined as possible. But for the defendant and the prosecutor and defense counsel on the Rye matter, we need to adjourn this from another day, so we're gonna start and continue this exam.
All right, so we'll stand by and then report back to you in break.
Yeah, I'll have my court officer and I'll Monica check in with you from time to time to get you updates, okay?
Yeah,
Thank you.
my plan, if we do something, is just stipulate all in and make my arguments and call them.
Good, that's fine, okay.
Mr. Honor.